3 minutes for a rebuttal. Good afternoon, Your Honors. We have 2 minor children that are the subject of these particular parties. The mother herself has another child with her husband who's 2, so there's a half-sibling involved. The father lives with his girlfriend and has no other children. These parties mediated an agreement that they would each enjoy the children 50-50. And so I guess my first burden is to prove that there has been a material and substantial change of circumstance such that this needs to be changed. And quite frankly, it never worked. But things began to be so bad that it was my client's obligation as a prudent parent to attempt to change this parenting plan because it was no longer in the best interest of these parties. Now, the court, in its findings, said, I'm not going to find a substantial change, that these are just mere parenting styles. But quite frankly, after 25 years of the practice of law, I respectfully disagree that the proof that was presented, very fact-intensive, was merely parenting styles. There was a minor daughter who had suicidal ideation and cutting. All of these are going to be occurring after that 50-50 plan. There was failure by the father to follow the pediatrician's recommendations, his admissions that he wasn't going to give the prescribed medications, even though he himself has no degree in the medical field. The children, one or both at different times, had accidents on the father's time, and while we submit accidents happen with children, the complaint was that they went for long periods of time in pain, would return to the mother, and on 3 separate occasions she thereafter took them to the doctor where they indeed had broken bones that had been gone untreated, uncared for. The father refused to participate in the education and the 504 analysis and the IEPs of the children. The little boy has ADHD. It was recommended that he get some medication. The father vehemently refused.
Let me ask you just real quick. I've read your briefing and I've read a large portion of the record, but I haven't read all of it. Did I read correctly that the child who has an ADHD diagnosis, that at some point father did agree to the medication?
Eventually did, but only after the case was filed and only after the guardian ad litem got involved and wrote a letter saying, we've got to intervene, we've got some emergent things going on. He eventually did agree, but it took 1 year to get him to that position in litigation, and he only agreed to it after there was the guardian ad litem involving. And the child failed. The child had to go to summer school. So these weren't short-term things where the father was considering it or trying to catch up. He went long time with disagreeing and not participating, leaving the mother handcuffed to make any decisions because it was
there another issue with another type of medication that I recall?
There were several other circumstances. One was with the young boy who had a gastrointestinal issue, and he was to take Prilosec, I think 10 milligrams a day. I could be wrong in the amount. And the father absolutely refused to do it for 2 years. Again, it wasn't a short-term thing. And he has no medical degree. He refused to talk. As a matter of fact, the record reflects in his testimony that he never called them, even though their brief says he did. He says in his testimony he didn't. And it got so bad that the doctor referred him for a scope and upped it to 20 milligrams a day and made sure it was set on the mother's time because the father just wouldn't give it. The father also, he was my best witness at trial. He admitted to all of this at trial, and he even said that he knew that he was supposed to give it, but not only did he not give it, refuse to give it, but he told his mother, the paternal grandmother, who he claimed was the primary caregiver during his 50% time, his words, he forbade her from giving the child the medication, even though the paternal grandmother called begging one day because he was so sick before taking him to school.
And I understand there are different parenting styles, but just for my clarification, mother is a nurse, is that correct?
That's correct. Yes, Your Honor. But we also did not rely solely on the mother, obviously. We put into the record all of the medical records to back up everything that I'm saying today. The father admitted that he wasn't in any way involved in the medical field, but that he just wasn't going to do it, and he refused to do it. He also refused with the daughter. She was not able to have bowel movements for whatever reason on the father's time. So she would go for, in his words, a period of time with a distended belly and not going to the bathroom. The doctor, pediatrician, said, let's try some Miralax. Father admits that he didn't do it. Father admits that he didn't monitor it. The mother would have to monitor it, and sometimes it got so bad that she had to do, other things to assist this child. But the father didn't deny it. The father didn't deny that the children were hurt on his time, and he waited until they went back to the mother for her to go. And we're not talking about a cold. We're only talking about things where the children had broken bones on his care that the mother had to deal with later, or an antibiotic that was needed. We can't get antibiotics without going to the doctor. Father testified he thought the child had strep during his time, but he wouldn't take the time to take the child. Only after the mother got the child back would she take the child, and sure enough, Dad was right. The child had strep, but he didn't take care of the child. The child had a concussion on the father's time when the little boy was out while they were working with a bulldozer, digging out a trench.
I think it was a backhoe.
Backhoe, thank you. I appreciate that. You're right. And he was hit, and it caused a concussion. Again, the mother was called by the school in order to take care of the child because he was experiencing headaches. These are constant and overwhelming problems that the mother has faced while the children are in the care of the father. But that's not all. I heard earlier some talk about Rajendran and how we're not supposed to do a 50-50 plan if the parents cannot co-parent. I know it was 2 times in the record for sure. It may have been 3, but I know it was 2. So I'll argue too that the court had to stop the proceeding to have the opposing counsel, not counsel today, but who was at the trial court, to take the father out in the hallway to calm him down. If the father couldn't control his demeanor in the courtroom with the eyes of the judge upon him during a cross-examination, I can only imagine what he was doing to my client. But we don't have to imagine, because he admitted to what he was doing to her. He admitted that he would say things like, I'm not going to listen to your bullshit, when she wanted to take the child who had been cutting herself to counseling. We had to get guardian ad litem intervention to get that started. These are material and substantial changes, and a mother screaming out to try to assist and protect the children with no communication or cooperation at all from the father. The father actually chastised the daughter for what she told the counselor in the counselor's office, saying that she was anxious about being in his home, or with the girlfriend, who she says threw her on the bed in discipline and spanked her. Dad says didn't happen, but the girlfriend took the stand, and it sure did. As a matter of fact, the girlfriend testified that not only did she spank the child, but she spanked the child with under the father's direction to do so while he sat in a chair and watched television. So for the court to find that the court found that all the parties were credible witnesses, I even have issue with that, because clearly the father was saying it didn't happen, and his own girlfriend took the witness stand and said that it did. The mother was doing everything she could to try to encourage the children. It was undisputed that the children, at least the oldest, would text the mother during the time that she was with the father, claiming she was scared, and mother would encourage her, it's going to be okay. She wasn't causing a ruckus or anything of that nature. She was doing what she's supposed to do in the statute. She kept him informed of appointments or tried to help get decisions. He would either not respond or deny, and denial is a form of non-parenting. If you just deny everything, they get to do nothing and get no treatment. He didn't pay his child support. That was stipulated. He didn't even pay it in between the first and second day of trials. He didn't pay medical expenditures.
While we're talking about that, I noted in the court's ruling on, it addresses civil contempt on page 5 and states the court finds the basis for the relief or finding of contempt has been addressed by the court. Where in the record can I find anything about whether this was determined to be willful or not, or anything along those lines?
Your Honor, in all due respect, I believe that when I read to you where the father's own testimony, that he testified that he bought a $5,000 trailer instead of paying his child support. We submitted Facebook posts where he talked about the 50-50 not being fair, and I'll use some very disparaging remarks. But we know that he admitted at trial that instead of paying his child support, he bought himself a $5,000 trailer. Child support was nowhere near the $5,000. And he also testified that he wasn't going to pay it on the date due unless the court made him. Well, the court had already ordered that it was due on the 1st of each month. And even after presenting him that order, saying it was due on the 1st, he still did not oblige, and he still didn't pay it by the time we got back to the second day of trial. And he said he wasn't going to. So his own proof, yet again, is the best proof that we had. He further was at the orthodontia appointment where the arrangements were set up for some dental work or orthodontia to be done. He never paid that either. And that was entered as a judgment. But then my client, who had to bring these actions in order to get the relief, wasn't awarded attorney fees, really no punishment, really no, nothing to hold him accountable or to stop that action in the future. There is clearly substantial change of circumstance. The court should have found it. And when you look at my brief where I went through every best interest analysis, which the court didn't do because they didn't get beyond substantial change of circumstance, I went through in every analysis and best interest either favors the mother for the proof so stated, or both equally. None of them favor the father. And for that reason, this should be overturned and the mother's parenting plan adopted. Thank you.
Good afternoon. May it please the court. My name is Paige Burnick with the law firm of Lewis Thomason. I represent the appellee, Kyle Hester, in this matter, also known as the father. What we didn't hear is that the trial court determined that father engaged with the children in outdoor experiences and activities, and that father had a very strong support system that benefited his children, and that father appropriately parented his children. As you know, the case arises from a parenting dispute between mother and father regarding the modification of the permanent parenting plan. The parties, again, as counsel has stated, have 2 minor children, and the initial parenting plan was established in September of 2019 as a 50-50 plan. In October 22, mother has filed the petition to modify the plan, alleging a material change in circumstances and seeking to alter the parenting arrangement. Trial court conducted a 2-day trial on 2 separate dates, February 28, 24, and April 24th, 24, during which the court heard testimony from both parents, witnesses, including the girlfriend, Jessica Choate, and the paternal grandfather, Delvin Hester. Juvenile Magistrate Judge Stark found all the witnesses to be credible, and Judge Stark heard all the evidence presented and reviewed all the evidence into the record. And after considering all this evidence, the court determined and denied the mother's petition, finding, again, no material change in the circumstances, and determining that the current parenting plan, the 50-50 plan, remains in the best interest of the children. The trial court also denied the mother's request for attorney's fees, the cost, and that willful finding, the civil contempt. Mother now appeals these decisions. I'd like to start that,
Well,
similar to.
as to the contempt,
Sure.
is that addressed anywhere, whether this is willful or not? I've read this, but I don't recall seeing that in the order. Can you point me to that?
Correct, there is no willful contempt in this order. It's on page 5, like you said, in the
Yeah,
record.
but it's not addressed at all.
It's not addressed at all, but it's brought up in appeal, but I'm not sure where else in the record that we see that. It's just
So it says it's addressed, but there's just not a finding
a finding.
of whether or not there is contempt or not.
Correct, and that's not there, but it's brought up, and I don't see where else in the record there was a finding of a willful contempt. I don't think that was ever addressed at the trial level. Again, I don't think you can bring that up at appeal at this appellate level. You have to allow these things to work out at the trial level before you can bring it up before the appeals court. Again, as we've said it under Tennessee Appellate Rule 13, it's a de novo review of the record accompanied by a presumption of correctness of the finding of the trial court unless a preponderance of the evidence is stated otherwise. And in these types of cases, the standard is very high to overturn the trial court. The Tennessee Supreme Court in Armbruster, that's the Tennessee Supreme Court case from 2013, has set forth the following with regard to parenting plans such as here. When they've quoted, because decisions regarding parenting arrangements are factually driven and require careful consideration of numerous factors, trial judges have the opportunity to observe the witnesses and make credibility determinations, and they are better positioned to evaluate the facts than at the appellate level. Thus, when the details of the parenting plan is peculiarly within the broad discretion of, or the peculiar details are within the discretion of the trial court, it's not the function of the appellate court to tweak or change the parenting plans in hopes of a more reasonable agreement than the trial court. The trial court's decision here is not to be reversed absent abuse of discretion, and we've heard the Supreme Court and Court of Appeals have 4 distinct areas where they find an abuse of discretion. That would be where a trial court applies incorrect legal standard, reaches an illogical result, resolves the case on clearly erroneous assessment of the evidence, or relies on the reasoning of causes of injustice. And that's from the Gonskewski case, Tennessee Supreme Court 2011. A trial court abuses its discretion in establishing a parenting schedule only when the trial court's ruling falls outside the spectrum of rulings that might reasonably result from the application of the correct legal standard in the evidence in the record. Our position is that mother has failed to show how the trial court applied that wrong legal standard, applied an illogical result, applied a clearly erroneous assessment of the evidence or causes of injustice. And I'll point to the trial record. The final order, we're looking at pages 161 to 168 of the trial record. And I'm turning to page 163 or page 3 of the record. The trial court says, over the course of 2 days, the court heard testimony from mother, the father, the paramour, Jessica Choate, and the paternal grandfather, Delvin Heston. All witnesses were found to be credible. The majority of the proof was the testimony of the mother and the father, and more specifically about their communication, decisions concerning the children, to include medical, school, extracurricular, or routine discussions about the children. Based upon the testimony that the court heard, they did and could communicate effectively, though they had disagreements about some decisions. They found that they were both very involved with the children during their parenting time, and both mother and father, although they had demanding jobs, did make time for their children. While they might not be fond of each other, the court acknowledged that. The court did also acknowledge at the bottom that the father's testimony was emotional and passionate at times and was compelling because he was genuinely trying and doing everything he could to be amicable when talking and working with mother concerning the children, and he was committed to co-parenting. So essentially, that what they're saying is the mother's proof was her dislikes or complaints about father's parenting or parenting style or choices, but at the end of the day, the court found that father tried to work these things out. In fact, I believe what the court found was that father did address his concerns, and he did present questions, and then he presented to the best of his ability. She's right, he's not a medical professional, but he did his best to learn and get educated about these issues. And then at the end of the day, he would concede to mom's position, and he would let mom make those medical decisions, and he would not challenge it. And what the court has described it to be an agree to disagree approach.
Let me ask you this. So in looking at this order, the first threshold that's got to be crossed here is whether there has been a material and substantial change of circumstances. And in reading the order, I see a lot of broad language that commends both parents, but what ultimately, mother filed this petition upon allegations of specific material and substantial changes of circumstance. Where does the court address those specific issues and whether they are or are not fitting or fit, whether they do or do not fit within the category of material and substantial change of circumstances? Because we have some very specific things that your opposing counsel brought up as far as the children's health and very specific needs that the children have as far as educational needs or medication needs or potentially some counseling needs that the mother is pointing to say there has been a material and substantial change. And I'm just not seeing in the order where the court analyzes those things and makes that determination of whether those are material and substantial changes that were contemplated by the parties at the time that they entered into their prior agreement.
You're right. I think the language is a little general. The language that the trial court uses is a very broad scope of what her findings were. And I agree that there is not a delineated, court findings addressing point by point each issue that mother brought up at the trial level. But with that said, it is in the order that the trial court said that they did acknowledge it and they did take into consideration. And I'm looking at page 4 of the trial order, where it said the mother introduced through testimony and evidence various illnesses, injuries of children, specifically the self-cutting and the ADHD diagnosis of Gunner. And father's testimony provided that in all these situations, father had concerns, he voiced the concerns, presented questions, and participated to the best of his ability. And I believe that the court, you're right, did not delineate every single issue that she had, but did acknowledge that mother had brought these things up and still felt that father was able to communicate and make an agreement with mother, which I think, I know that counsel relied on heavily the Rajanjan and Barmanesh cases where they discussed about that inability to communicate between the parents. And I want to point out that I think that is not the case here. I think the case here is that they do communicate and they try their best to communicate. But I don't think...
I haven't read the record entirely, but there's some fairly unkind things that were said in this record. Is that not correct?
There are, Your Honor. There are. But there's also very passionate and very inflamed emotions in this situation in somebody's family. And as you know, it gets passionate at those times. But at the end of the day, as the court noticed, and the trial court determined, father was able to concede and went about mother's wishes. He had an agree to disagree approach to the parenting. He would allow mother to do the things that she wanted to do or what her interests were.
Sorry. But
Sure.
Even in conjunction with that, if he conceded or he went about her wishes, is the proof in the record, though, not that he would still refuse to give the medications and still refuse to take whatever affirmative actions were necessary as far as the daughter's gastrointestinal issues or the son's medication that he needed?
I believe that the testimony from father is that eventually he did. He did question and push back. I can't quote you exactly where in the record. I recall that, and I think it was from that second day of testimony, but where father did address that he eventually did. He had concerns. He didn't want his children on long-term medications like the ADHD. He didn't know about that ADHD medication. I remember him having concerns that what's the long-term effect of somebody being on that medication as a child. And I remember, and also with the Prilosec too, he didn't know that hurt somebody's their gastrointestinal lining. And
Wait.
so he expressed. Go ahead.
You're saying that he didn't know. Is there proof in the record that he took the initiative to learn about that?
He did. He testified to that. He testified that he acknowledged it and that he learned more about it. And then eventually he did go forward with mother's wishes to give that medication.
After some time.
After some time, yes. But he did. And he did present his questions, and he did eventually go forward with her recommended course of action.
Well, let me ask you another question, and you've already read from the portion of the record earlier that listed out all of the witnesses and said the court finds them all to be credible. Your opposing counsel says that some of those witnesses gave contradictory testimony, but yet the court says they're all credible.
And I believe she says, too, that sometimes there are agreements to disagree in parenting. That I believe it's the last page on her conclusion, that differences of opinions concerning the children will always occur when being raised in a home with both parents and raised in two separate homes. And she found that while, yes, there's passion and there might be disagreements, there's always going to have a different in parenting styles. And I think the way that the record's been presented is it's very consistent with that, yeah, you might have different parenting styles, when you might go call a doctor, or when you might use children's Motrin before you call a doctor. But that is what the trial court said. And they said that she says,
I think perhaps I misstated my question. What I'm specifically referring to here is we have a credibility finding by the court saying all the witnesses are credible, but the witnesses didn't all say the same things. So how do you reconcile that? How do you argue that this court should interpret that credibility finding when essentially the trial court has said everybody is credible, but I think opposing counsel gave an illustration of of an instance where your client and his paramour gave two different stories of the same event. So how do we then look at it under our standard of review? How do we process that credibility finding when we have a finding that everybody's credible, but yet their stories contradict each other?
I think you have to look at the totality of what is being said. I don't think you can take single instances of inconsistency as just evidence, because I think you're in family court. It is much more impassioned, and people are angry, and they are in a bad state. And I think what you could look at, Your Honor, is looking at the totality of what was being said. Yes, you might have direct instances where you disagree of what happened, but on the totality of how things are approached outside of people's emotions, I think you could still make a credibility assessment of the witness.
Okay.
I see that your time is up. Thank you.
Thank you, Your Honor.
I'd like to finish on the communication issues between the parties that my worthy adversary brought up. The father told the daughter that the mother is the stupidest bitch he's ever met. The father told the mother's husband that he indeed did say it, and he just couldn't help it, that he had to somehow let out his frustrations. The father wrote on Facebook, an exhibit of the court, 50-50 don't mean shit when it comes to child support. I guess for some reason people just don't feel entitled to a handout. Some leeches you just can't ever get rid of. And on the witness stand, father stated and admitted that he does not respect the mother at all, and his actions from the time the parenting plan has been entered forward has indeed proven his statement to be true. Also on communication, the court found they communicated with one another, but the proof shows, and the father admits, that he didn't go to the school meeting initially. He sent the paternal grandmother to go in his place. that he didn't take the child to the doctor, that he let his girlfriend pretend to be the mother to take the child into the doctor while he sat in the car and babysat the dog. These are his admissions. These are his testimonies. These are the things that the mother is having to deal with in the parenting arrangement. That they continue to discuss it, and he finally concedes a year after the fact on ADHD medicine and summer school, and 2 years on gastroenterologist medicine to get an endoscope for this needed child, is showing that he's shirking his responsibility. He doesn't communicate with her when he goes out of town for work, sometimes 3 weeks at a time. He doesn't communicate with her when he goes hunting out of state. He doesn't even communicate with her when he takes the children out of state. He literally scheduled a Florida vacation for the children and himself to go to Florida on the mother's parenting time, while the children would have to miss school after they'd already been sick. We know one of them has been sick and had missed 8 days. The mother said, no, they can't miss more school. They can't miss it. And by the way, it's my parenting time anyway. And what did the father do? The father admitted that he picked up the phone, he put it on speakerphone, had the children listen in as he tried to coerce the mother into letting them go. So in his words, so he wouldn't have to be the bad guy in saying no to the trip to Florida. And he admitted at trial he shouldn't have done it. But all the shouldn't does and wouldn't does and couldn't does doesn't give the relief to this mother, and more importantly, to give these children the stability they need under the mother's proposed parenting plan. It just continues. Thank you.
All right, you can call the next case.
In re Lucas S.